So one of the things we want for you as a business or a business owner is a way to efficiently resolve business disagreements and fights that come up. And I'll tell you right now that the court system is not designed to be efficient. It's not optimized for efficiency. And in fact, it can be very expensive, very time consuming, and very tedious. And just out of necessity, because of all the fairness safeguards that are in place and giving everybody the opportunity to be heard, you don't really get feedback or a decision on the strength of your position until the very end, after you've spent a lot of money and spent a lot of time going through a public process. And so that's just the reality of what the judicial system is like. And because of those obvious inefficiencies, people have turned to alternative dispute resolution. And two of the most notable types of alternative dispute resolution include arbitration and mediation. Usually those are framed as alternatives to the judicial system. Sometimes they can be off-ramps from the judicial system. Arbitration is where you select an arbitrator, such as AAA or JAMS or a certain individual who will decide your case. And mediation is where you select a mediator who will help the parties negotiate, who will facilitate, who will not decide your case, but will offer solutions and help you reach a compromise. Now, the advantages of arbitration are really threefold. One is that the process of arbitration is not public. So your dirty laundry is not being aired in the very public court system. Two is speed. Arbitration is generally going to be a faster process for you. Not necessarily less expensive, but faster. And then three is expertise. You're going to have a really solid decision maker. And for industry-specific cases, you can even select a decision maker who's familiar with your industry. The advantages of mediation are going to be, again, lots of confidentiality. So you're able to speak freely and your dirty laundry is not going to be aired for the public. Also, control over your outcome. When you're in court, you're handing your power to jurors or to judges who don't know you, don't care specifically about you, and don't have necessarily your best interest at heart. And they're going to make a decision, and you've handed them that power. When you're mediating or negotiating a solution, you retain some of that power and can at least shape the outcome. And then three, closely related to that, is you can obtain outcomes in mediation that you can't obtain in court. Generally, when you go to court, you can only ask the judge to award you money, or the other side's going to ask for a money judgment. If you're in mediation and shaping an agreement to resolve the dispute, you can ask for all kinds of things that aren't necessarily just reduced to money. You could agree on some new venture. You could ask for an apology or give an apology. And there are other ways to resolve a dispute other than that aren't necessarily available and aren't something that a judge could order in the case. Now, one important thing about both arbitration and mediation is that it can only happen when everybody agrees for it to happen. So with arbitration, oftentimes you'll see an agreement that says if there's a dispute, then it will go to arbitration. And that's called a pre-dispute arbitration agreement. Other times a dispute comes up and the people say, well, let's submit this to an arbitrator. And that would be a post-dispute arbitration agreement. In any event, arbitration only happens when there is an agreement. And the same is true of a settlement conference or a mediation. The people need to agree that they will participate in that process. They don't have to agree to settle it. They just have to agree to participate in the process. And so the question comes up, well, when is arbitration and mediation unavailable? Well, the main answer is it's not available if not everybody's agreeing to participate in that format. And if they're not agreeing to participate in that format, you're going to be left with A, do nothing, or B, resort to the court system. In terms of the cost and the timelines, business litigation is probably going to take you approximately 1.5 to 3 years to resolve through the court system. If the parties are amenable to a settlement conference, usually that can be scheduled and concluded within about 60 to 90 days. So that's a pretty attractive off-ramp to the litigation system. For an arbitration, I would say that an arbitration can be accomplished in about 9 months to 1.5 years. And if you agree to accelerate it, the arbitrator will accommodate that and will accelerate it for you. So your outcomes are going to be different in alternative dispute resolution versus a court trial. In a court trial, there's more of a chance that there's going to be a winner and a loser. Sometimes the judge or the jury will split the baby, but that's not as common. In an arbitration, there's a better chance of a mixed result because your arbitrator is going to look at all the issues and maybe rule for you on this issue, rule for the other side on that, and they're more likely to spend more time dissecting in a way that we wouldn't really ask a jury to dissect. They're not sophisticated enough to dissect a case, issue by issue. Whereas your arbitrator is going to have that sophistication. And then lastly, if you're in a mediation process and negotiating your outcome, that outcome is going to be one that everybody decided that they can live with, which you won't get in court. But everybody will decide that they can live with it, and it's probably going to include some components that a court could never order. And so there's going to be a little bit more creativity and imagination that goes into that outcome. So if you're a business owner who's thinking about arbitration, mediation as alternatives to the court process, you're on the right track and you're thinking about the right things. If you have any questions about those processes, please give us a call at the Sierra Crest Business Law Group.